When you own a property, you either have freehold or leasehold ownership of a property. An example of freehold would be a single family home that you own outright or you own with a mortgage on title, but essentially you have rights to that property directly. A leasehold property, an example of that might be a mobile home on a leased lot, or sometimes you will also see lake properties that are on crown land, which are essentially life leases, and they are leased properties. The title of a property is essentially the deed of ownership that you gain when you fully take possession of that property on closing date. Different types of ownership in real estate might be broken down into sole ownership, joint tenancy, tenancy in common, or community property. And that just essentially means, who do you own the property with? Is it another business partner? Maybe it's a sibling. Is it your spouse? Or is there a group of people that own the property together? Easements and encumbrances. The easy difference between those two words that are very similar is essentially an easement is an agreement that you've made with the neighbor to have them have some sort of access to your property. And an encumbrance is when your neighbor might have part of their ownership on your side of the property without said agreement. For example, two neighboring acreages share the same well, but that well is on one of two properties, but there's an easement on title that says both neighbors have access to that well and have rights to that well. If you go to sell that property, you need to recognize if there is an easement on title, and if you are going to purchase a property with a well on it and you don't want to share that well with your neighbor, that's something that you want to make sure that you've arranged prior to closing. As an example, an encumbrance would be where your fence is on the neighbor's property and there is no easement in place, where now you are encumbering on the neighbor's property, and essentially they have rights to take down your fence because your fence is on their property. Zoning is a very important part of the legal process in real estate. We have residential, commercial, industrial, and mixed use zoning. Now, if you're looking to buy a house, of course it would be zoned residential, or again, if you're looking at an acreage, it might be zoned farm or agricultural, or it might be zoned residential, and you might want to know that if you're looking at buying in a small town or surrounding area. When you're looking to purchase a piece of property, of course there is a bill of sale that takes place, and there's usually a real estate commission, a governing body that has mandatory forms that real estate agents are required to use when they're representing a buyer or seller in a purchase or sale of a piece of real estate. And in the big scheme of things, what most matters is that you have a real estate agent that you can trust. And as real estate agents as well, we have errors and omissions insurance, so that if something does go sideways with a transaction, we have insurance to make sure that we're covered. If you are in the commercial real estate side of things, they typically purchase additional liability insurance to make sure if something ever goes wrong that they are covered. And of course, the governing body is here to represent the public to make sure that the agents are doing what they are supposed to be doing, and essentially what we call fiduciary duties. When you're looking to make an offer to purchase, you want to make sure that you have contingencies in place, and those contingencies are typically your home inspection, your disclosure statements, and your financing condition. Once conditions are removed, typically the earnest money or the deposit money is now non-refundable to the buyer, and that deposit money goes into a trust account with the buyer's brokerage or the seller's brokerage, or possibly with the lawyer's or title company's trust account. Until possession date, it goes towards the down payment and becomes good faith money that the buyer is fully intending to follow through with the sale. Once you get to the closing table, you're going to need to go to the title company office or the lawyer's office to make sure that you sign everything, all the T's are crossed and the I's are dotted. Either the cash is ready in place or the mortgage documents are all fully ready to go and the lawyer has access to them and everything looks ready to close. You literally sign with the lawyer's office and you are moving forward to transfer title from the the seller to the buyer on possession date. It's key to understand what acceptance truly is when you're looking at negotiating a real estate deal. Acceptance is not acceptance until it's been communicated in writing. What you'll sometimes see happen during a real estate negotiation is that the conversations go back and forth and they become verbal negotiations. Sometimes there's some nitty-gritty details that needed to be sorted out, but if you're in the middle of negotiating back and forth verbally and all of a sudden a new offer comes in that's much stronger, that's a cash offer with no conditions, even if you said yes, we've got a handshake, yes, we've got a deal with the first arrangement, it's not technically a deal until acceptance has been communicated in writing. So they could say, yes, we have a deal, and then they say, actually, sorry, we've got a new offer, everything's changed. So you don't technically have a deal until it's been communicated in writing, until you have an offer that's been accepted and you've got it signed, or a counter offer that's been accepted and signed by both parties. Of course, we have all different types of contracts and agreements. We have listing agreements, buyer brokerage agreements, we have sales contracts, and we have leasing contracts. There's a variety of different things that you need to make sure that you have when you're looking at doing a purchase or a sale. When it comes time to possession date, if one party or the other is not upholding their end of the bargain, that's what we would consider a breach in contract. And what I've heard from lawyers, they say essentially possession is, 7/10 of the law. After possession, there's always the option to sort things out amicably through mediation, but worst case scenario, if there are damages based on a breach in contract, that's where you'd see small claims court come into play potentially. When you're looking at buyer and seller representation from the agent side to the buyer or seller side, we call that an agency relationship. Like what I'd said before, you've got fiduciary duties as a real estate agent to make sure that you represent the public's best interest. And if you are representing the buyer and the seller in such a scenario, you're essentially representing both sides, and you need to be able to disclose to both parties that there could potentially be information shared with both sides because you're representing both parties. And in a lot of markets, they don't actually let you represent both sides. We had mentioned in passing mandatory disclosures. You will see sometimes a disclosure about permits. Sometimes you'll see disclosures as to any latent defects with the property, whether or not the roof has leaked or the basement has leaked, or if the property's ever flooded or had mold or had, history of, a drug house or anything of that nature should be in that disclosure statement. And you very often will see that become a condition of sale. If you have further questions about real estate law, I am connected to some really great legal people that help me with that side of the process. Of course, as licensed agents, we need to make sure that we stay on top of our continuing professional development. But again, if you are a newer agent and you're looking to choose brokerages, feel free to send me an email. I'll be happy to help. Otherwise, thanks for being here today. Don't forget to like, comment, and subscribe. And I will see you on this video next. Have a fantastic day.